After studying this module, you shall be able to know what is Drug and Cosmetic Act and how it came into existence. What are the different provisions regarding the import of drugs and cosmetics? You shall be able to learn about the different provisions related to the manufacture, sale and distribution of drugs and cosmetics. You shall be able to know what is Central Excise Act. We will study its historical background, and you shall be knowledgeable and you shall be able to comprehend what is central excise duties and their levy and collection. And you shall also be able to know and be familiar with NDPS Act and about the different chapters of NDPS Act. In 1937, in the Central Legislative Assembly, a bill was introduced to bring the recommendations of the Drugs Enquiry Committee into framework for regulating the drugs import into British India. The committee concluded that more uniformity in the import, manufacture and distribution of drugs was desirable. The Indian government accordingly directed the government of provinces to ask the provincial legislature to pass such resolutions which can aid the central legislature to pass an act which could regulate such matters. And after that, the Drugs and Cosmetics Bill was introduced in the Central Legislative Assembly. And finally, the Drugs and Cosmetic Act came into existence on 10th April 1940, and it was meant to regulate the import, manufacture, distribution and sale of drugs and cosmetics. In the most simple form, excise may be defined as any duty, toll or tax imposed upon the consumption or sale or manufacture of commodities in a country, or tax upon certain trades, sports or occupations, generally taking as fees or licenses. In a series of judgments over years, the Supreme Court of India has held that excise duty is essentially a tax on production or manufacture of excisable goods produced or manufactured within the country and is completely unrelated to the sale of the same. In order to systemize the taxation system, the Central Excise Act 1944 was promulgated. It is the basic act which deals with the charging of duty, valuation of goods and administrative and penal provisions. This act has 7 chapters containing 40 sections and now only one schedule, that is second schedule, which has only one word, tobacco, on the possession of which section 8 places a restriction. Schedule is no more part of this act now. The NDPS Act of 1985 was implemented on 23rd August 1985 in the Lok Sabha. It was passed by both the Houses of Parliament and was approved by the President on 16 September 1985. However, this act came into existence or application on 14th November 1985 and came to be known as Narcotic Drugs and Psychotropic Substances Act, abbreviated as NDPS. Under the NDPS Act, it is illegal for a person to produce or manufacture or cultivate or possess sell, purchase, transport, store and or consume any narcotic drug and or psychotropic substance. In one of the requirements under this Act, the Narcotics Control Bureau was formed with effect from 1986 year in the month of March. This Act was constituted to accomplish India's treaty obligations under the Single Convention on Narcotic Drugs, Convention on Psychotropic Substances and United Nations Conventions against the illicit traffic in narcotic drugs and psychotropic substances. The Act has been amended 3 times, first in 1988, then in 2001 and most recently in 2014. Chapters of Drugs and Cosmetic Act. The Act is divided into 5 chapters containing 38 sections and 2 schedules, namely the Schedule 1 and the Schedule 2. And if we try to see what are the chapter wise contents of this Act, that is the Drugs and Cosmetic Act, they are: the first chapter is introductory, where title, extent and commencement is there in section 1, followed by definitions which are given in section 3, and the presumptions as to poisonous substance are given in section 4. Second chapter deals with the Drugs Technical Advisory Board, the Central Drugs Laboratory and the Drugs Consultative Committee. And here again it is, if you look at the sections under this chapter, the section 5 relates to Drugs Technical Advisory Board, the section 6 relates to Central Drug Laboratory and section 7 pertaining to the Drugs Consultative Committee. Chapter 3 deals with the import of drugs and cosmetics, and under this the section 8 deals with the standards of quality. Section 9A to D deals with misbranded, adulterated and spurious drugs and cosmetics. Section 10 deals with the prohibition of import of certain drugs or cosmetics. Section 12 to 15 deals with central government's power to make rules and related provisions. Fourth chapter deals with the manufacture, sale and distribution of drugs and cosmetics. Under this again, all these sections, the section 16 is for standards of quality, section 17A to D deals with misbranded, adulterated, spurious drugs and cosmetics, section 18 dealing with prohibition of manufacture and sale of certain drugs and cosmetics, section 20 talks about government analyst, section 21 to 23 highlight on the role of inspector, his powers and procedures. Section 22 is about persons bound to disclose place where drugs or cosmetics are manufactured or kept. Section 27 to 30 is about the penal provisions. Section 31 is about confiscation. Section 32 is about cognizance of offences, and section 33 is about the power of central government to make rules. Chapter 4A, which is about the provisions relating to Ayurvedic, Siddha and Unani drugs. So here we have section 33A to O, which deals with Ayurvedic, Siddha and Unani drugs, Technical Advisory Board, the Consultative Committee, penal and related provisions. And then we have chapter 5, which is the miscellaneous chapter, and under this section 33, 34 and 34A, they relate with the adjudication of confiscations and penalties independent of punishments. Section 34 deals with offences by companies. Section 35 deals with publication of sentences passed under this Act. Section 36 is about the magistrate's power to impose enhanced penalties. Section 37 deals with the protection of action taken in good faith, and Section 38 deals with the rules to be laid before the Parliament. Important definitions which are there in Drugs and Cosmetic Acts. Cosmetics. According to the Section 3 AAA, cosmetic term means any article intended to be rubbed, poured, sprinkled or sprayed on, or introduced into, or otherwise applied to the human body or any part thereof for cleansing, beautifying, promoting attractiveness or altering the appearance, and includes any article intended for use as a component of cosmetic. Drug. According to the Section 3B, drug includes all medicines for internal or external use of human beings or animals, and all the substances intended to be used for or in the diagnosis, treatment, mitigation or prevention of any disease or disorder in human beings or animals, including preparations applied on the human body for the purpose of repelling insects like mosquitoes. They also include such substances other than food intended to affect the structure or any function of the human body, or intended to be used for the destruction of vermin or insects which cause disease in human beings or animals, as may be specified from time to time by the central government by notification in the official gazette. Drug also include all the substance intended for use as components of a drug, including empty gelatin capsules. The term drug also includes such devices intended for internal or external use in the diagnosis, treatment, mitigation or prevention of disease or disorder in human beings or animals, as may be specified from time to time by the central government by notification in the official gazette after constitution with the board. Government analyst. According to Section 3C, government analyst means in relation to Ayurvedic, Siddha or Unani drug, a government analyst appointed by the central government or state government under Section 33F, and in relation to any other drug or cosmetic, a government analyst is appointed by the central government or a state government under Section 22. Manufacture. According to Section 3F, the term manufacture in relation to any drug or cosmetics includes any process or part of a process for making, altering, ornamenting, finishing, packing, labeling, breaking or otherwise treating or adopting any drug or cosmetic with a view to its sale or distribution, but does not include the compounding or dispensing of any drug or the packing of any drug or cosmetic, and in the ordinary course of retail business, and to manufacture shall be construed accordingly. Provisions regarding the import of drugs and cosmetics. The Chapter 3 of Drugs and Cosmetic Act deals with various provisions regarding the import of drugs and cosmetics. The sections under this chapter not only define the standards of quality for import of drugs and cosmetics, but they also define misbranded, adulterated and spurious drugs and cosmetics. The standards of quality. The expression standard quality means in relation to a drug that the drug complies with the standard set out in the second schedule, and in relation to a cosmetic that the cosmetic complies with such standard as may be prescribed. The central government, after consultation with the board and after giving by notification in the official gazette not less than 3 months notice of its intention so to do, may be a like notification add to or otherwise amend the second schedule for the purposes of this chapter, and thereupon the second schedule shall be deemed to be amended accordingly. Misbranded drugs. Section 9 of chapter 3 defines this. A drug shall be deemed to be misbranded if it is so colored, coated, powdered or polished that damage is concealed, or if it is made to appear of better or greater therapeutic value than it really is, or if it is not labeled in the prescribed manner, or if its label or container or anything accompanying the drug bears any statement, design or device which makes any false claim for the drug or which is false or is misleading in any particular. Adulterated drugs. According to section 9A of chapter 3, a drug shall be deemed to be adulterated if it consists in whole or in part of any filthy, putrid or decomposed substance, or if it has been prepared, packed or stored under insanitary conditions whereby it may have been contaminated with filth or whereby it may have been rendered injurious to health, or if its container is composed in whole or in part of any poisonous or deleterious substance which may render the contents injurious to health, or if it bears or contains for purposes of coloring only a color other than which has been prescribed, or if it contains any harmful or toxic substance which may render it injurious to health, or if any substance has been mixed therewith so as to reduce its quality or strength. The spurious drugs. Section 9B of chapter 3 talks about this. According to section 9B of chapter 3, a drug shall be deemed to be spurious if it is imported under a name which belongs to another drug, or if it is an imitation of or a substitute for another drug or resembles another drug in a manner likely to deceive, or bears upon it or upon its label or container the name of another drug unless it is plainly and conspicuously marked so as to reveal its true character and its lack of identity with such other drug, or if the label or the container bears the name of an individual or company purporting to be the manufacturer of the drug which individual or company is fictitious or does not exist, or if it has been substituted wholly or in part by another drug or substance, or also if it purports to be the product of a manufacturer of whom it is not truly a product. So, all these false claims are leading to the drugs with a spurious nature, that is, they are the spurious drugs. Misbranded cosmetics. According to section 9C of chapter 3, a cosmetic shall be deemed to be misbranded if it contains a color which is not prescribed, or if it is not labeled in a prescribed manner, or if the label or container or anything accompanying the cosmetic bears any statement which is false or misleading in particular. Spurious cosmetics. According to section 9D of chapter 3, a cosmetic shall be deemed to be spurious if it is imported under the name which belongs to another cosmetic, or if it is an imitation of or is a substitute for another cosmetic or resembles another cosmetic in a manner likely to deceive or bear upon it or upon its label or container the name of another cosmetic, unless it is plainly or conspicuously marked so as to reveal its true character and its lack of identity with such other cosmetic, or if the label or the container bears the name of an individual or company purporting to be the manufacturer of the cosmetic, which individual or company is fictitious or does not exist, or if it purports to be the product of a manufacturer of whom it is not truly a product. Prohibition of import of certain drugs or cosmetics. According to section 10, from such date as may be fixed by the central government by notification in the official gazette in this behalf, no person shall import any drug or cosmetic which is not of standard quality. No person shall import any misbranded drug or misbranded or spurious cosmetic, or any adulterated or spurious drug. No person shall import any drug or cosmetic for the import of which a license is prescribed otherwise than under and in accordance with such license that should be there. No person shall import any patent or proprietary medicine unless there is displayed in the prescribed manner on the label or container thereof the true formula or list of active ingredients contained in it, together with the quantities thereof. No person shall import any drug which by means of any statement, design or device accompanying it, or by any other means purports or claims to cure or mitigate any such disease or ailment, or to have any such other effect as may be prescribed. Any cosmetic containing any ingredient which may render it unsafe, safe or harmful for use under the directions indicated or recommended. No person shall import any drug or cosmetic, the import of which is prohibited by rule made under this chapter, provided that nothing in this section shall apply to the import subject to prescribed conditions of small quantities of any drug for the purpose of examination, test or analysis or for personal use. Provided further that the central government may, after consultation with the board by notification in the official gazette, permit, subject to any conditions specified in the notification, the import of any drug or class of drugs not being of standard quality. The power of central government to prohibit import of drugs and cosmetics in public interest. According to section 10A, without prejudice to any other provision contained in this chapter, if the central government is satisfied that the use of any drug or cosmetic is likely to involve any risk to human beings or animals, or that any drug does not have the theoretical value claimed for it or contains the ingredients and in such quantity for which there is no therapeutic justification, and that in the public interest it is necessary or expedient so to do then that government may by notification in the official gazette prohibit the import of such drug or cosmetic. Offences. According to the section 13(1), whoever himself or by any other person on his behalf, his or her behalf, imports any drug deemed to be adulterated under section 9A or deemed to be a spurious drug under section 9B or any spurious cosmetic referred to in section 9D or any cosmetic of the nature referred to in the clause EE of section 10 shall be punishable with imprisonment for a term which may extend to 3 years and a fine which may extend to about 5,000 rupees. Any drug or cosmetic other than a drug or cosmetic referred to in clause A, the import of which is prohibited under the section 10 or any rule made under this chapter shall be punishable with imprisonment for a term which may extend to 6 months and or with fine which may extend to 500 rupees or with both. It also says that any drug or cosmetic in contravention of the provisions of any notification issued under section 10A shall be punishable with imprisonment for a term which may extend to 3 years or with fine which may extend to 5,000 rupees or with both. Further it says that whoever having been convicted of an offence A under clause A or clause C of subsection 1 is again convicted of an offence under that clause shall be punishable with imprisonment for a term which may extend to 5 years with fine which may extend to 10,000 rupees or with both. And B under the clause B of subsection 1 is again convicted of an offence under that clause shall be punishable with imprisonment for a term which may extend to 1 year or with fine which may extend to 1,000 rupees or with both. Confiscation. According to section 14, where any offence punishable under section 13 has been committed, the consignment of the drugs or cosmetics in respect of which the offence has been committed shall be liable to confiscation. So, all these goods will be confiscated. Jurisdiction. According to section 15, no court inferior to that of a metropolitan magistrate or a judicial magistrate of the first class shall try an offence punishable under the section 13. Provisions regarding manufacture, sale and distribution of drugs and cosmetics. Chapter 4 of Drugs and Cosmetic Act deals with various provisions regarding the manufacture, sale and distribution of drugs and cosmetics. The sections under this chapter also cover the penal provisions as to the non-compliance of necessities of the manufacture, sale and distribution of drugs and cosmetics mentioned under this act. According to section 18, from such date as may be fixed by the state government by notification in the official gazette, in this behalf no person shall himself or by any other person on his or her behalf will do these. First, the manufacture for sale or for distribution or sell or stock or exhibit or offer for sale to distribute any drug which is not of standard quality or is misbranded or is adulterated or is spurious. Second, any cosmetic which is not of standard quality or is misbranded or spurious. Third, any patent or proprietary medicine unless there is displayed in the prescribed manner on the label or container thereof the true formula or list of active ingredients contained in together with the quantities thereof. Any drug which by means of any statement, design or device accompanying it or by any other means purports or claims to prevent, cure or mitigate any such disease or ailment or to have any such other effect as may be prescribed. Fifth, any cosmetic containing any ingredient which may render it unsafe or harmful for use under the direction indicated or recommended. Sixth, any drug or cosmetic in contravention of any one of the provisions of this chapter or any rule made thereunder. Similarly, point B, it is prohibited to sell or stock or exhibit or offer for sale or distribute any drug or cosmetic which has been imported or manufactured in contravention of any of the provisions of this Act or any rule made thereunder. C, manufacture for sale or for distribution or sell or stock or exhibit or offer for sale or distribute any drug or cosmetic except under and in accordance with the conditions of a license issued for such purpose under this chapter, provided that nothing in this section shall apply to the manufacture, subject to prescribed conditions of small quantities of any drugs for the purpose of examination, test of analysis. So, these are excluded. Disclosure of the name of the manufacturer, etc. According to section 18A, every person not being the manufacturer of a drug or cosmetic or his or her agent for the distribution thereof shall, if so required, disclose to the inspector the name, address and other particulars of the person from whom he or she has acquired that particular drug or cosmetic. Reports of government analysts. According to section 25, the government analyst to whom a sample of any drug or cosmetic has been submitted for a test or analysis under the subsection 4 of section 23 shall deliver to the inspector submitting it a signed report in triplicate, that is 3 copies, in the prescribed form. The inspector on receipt thereof shall deliver 1 copy of the report to the person from whom the sample was taken and another copy to the person, if any, whose name, address and other particulars have been disclosed under the section 18A, and shall retain the 3rd copy for use in any prosecution in respect of the sample. Any document purporting to be a report signed by a government analyst under this chapter shall be evidence to the facts stated therein, and such evidence shall be conclusive unless the person from whom the sample was taken or the person whose name, address and other particulars have been disclosed under the section 18A has within 28 days of the receipt of a copy of the report notified in writing the inspector or the court before which any proceedings in respect of the sample are pending that he or she intends to adduce evidence in contravention of the report. So, within 20 days this filing should be done. Unless the sample has already been tested or analyzed in the Central Drugs Laboratory, where a person has under subsection 3 notified his intention of adducing evidence in contravention of a government analyst report, the court may, of its own motion or its discretion at the request either of the complainant or the accused, cause the sample of the drug or cosmetic produced before the magistrate under subsection 4 of section 23 to be sent for test or analysis to the said laboratory, which shall make the test or analysis and report in writing signed by or under the authority of the director of Central Drugs Laboratory. The results therefore and such report shall be conclusive evidence of the fact stated therein. The cost of a test or analysis made by Central Drugs Laboratory under subsection 4 shall be paid by the complainant or accused as the court shall direct. So, all these things you should keep in mind. The power of central government to prohibit manufacture etc. of the drug and cosmetics in public interest. According to the section 26A, without prejudice to any other provision contained in this chapter, if the central government is satisfied that the use of any drug or cosmetic is likely to involve any risk to the human beings or animals, or that any drug does not have the therapeutic value as claimed or purported to be claimed for, or it contains ingredients and in such quantity for which there is no therapeutic justification, and that in the public interest it is necessary or expedient so to do, then the government may by notification in the official gazette prohibit the manufacture, sale or distribution of such drug or cosmetic. Penalty for manufacture, sale etc. of drugs in contravention of this chapter. According to section 27, whoever himself or herself or by any other person on his or her behalf manufactures for sale or distribution or sells or stocks or exhibits or offers for sale or distributes any of these: A. Any drug deemed to be adulterated under section 17A or spurious under section 178. B. Or which when used by any person for or in the diagnosis, treatment, mitigation or prevention of any disease or disorder is likely to cause his death or is likely to cause such harm on his or her body as would amount to grievous hurt within the meaning of section 320 of the Indian Penal Code solely on account of such drug being adulterated or spurious or not of standard quality, as the case may be, shall be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to a term of life with fine which shall not be less than 10,000 rupees. If any drug is deemed to be adulterated under section 17A, but not being a drug referred to in clause A, or without a valid license as required under clause C of section 18, shall be punishable with imprisonment for a term which shall not be less than 1 year, but it may extend to 3 years, and with fine which shall not be less than 5,000 rupees. Provided that the court may, for an adequate and special reasons to be recorded in the judgment, impose a sentence of imprisonment for a term of less than a year and of a fine of less than 5,000 rupees. If any drug deemed to be spurious under section 17B, but not being a drug referred to in clause A, shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend to 5 years, and with fine which shall not be less than 5,000 rupees. Provided that the court may, and for any adequate and special reasons to be recorded in the judgment, impose a sentence of imprisonment for a term of less than 3 years, but not less than 1 year. Any drug other than a drug referred to in clause A or clause B or clause C in contravention of any other provision of this chapter or any rule made thereunder shall be punishable with imprisonment for a term which shall not be less than 1 year, but which may extend to 2 years, and with fine. Provided that the court may, for any adequate and special reasons to be recorded in the judgment, impose a statement of imprisonment for a term of less than 1 year. Penalty for manufacture, sale, etc. of cosmetics in the contravention of this chapter. According to section 27A, whoever himself or herself or by any other person on his or her behalf manufactures for sale or for distribution or sells or stocks or exhibits or offers for sale any cosmetic deemed to be spurious under section 17C shall be punishable with imprisonment for a term which may extend up to 3 years and with fine. Similarly, any cosmetic other than a cosmetic referred to in clause 1, as we have already studied above, in contravention of any provision of this chapter or any rule made thereunder shall be punishable with imprisonment for a term which may extend to 1 year and or with fine which may extend to 1000 rupees or with both. Penalty for manufacture etc. of drugs or cosmetics in contravention of section 26. According to section 28B, whoever himself or herself or by any other person on his or her behalf manufactures or sells or distributes any drug or cosmetic in contravention to the provisions of any notification issued under the section 26A shall be punishable with imprisonment for a term which may extend to 3 years and shall also be liable to a fine which may extend to 5000 rupees. Penalty for use of government's analyst report for advertising. According to section 29, whoever uses any report of a test or analysis made by the Central Drugs Laboratories or by a government analyst or any extract from such report for the purpose of advertising any drug or cosmetic shall be punishable with fine which may extend to about 5000 rupees.
Different provisions of Central Excise Act. The Act is divided into 7 chapters containing 40 sections and now only one schedule, namely Schedule 2. The chapter-wise contents of this Act are: Chapter 1, Preliminary. Title, Extent and Commencement, Section 1. Definitions, Section 2. Chapter 2, Levy and Collection of Duty. Duties specified in Schedule to Central Excise and Salt Act 1985 to be levied. Section 3. Valuation procedure for purposes of charging duty of excise. Sections 4, 5 and 5A. Registration. Section 6. Restriction on possession of goods, tobacco, offences, penalties and forfeiture of goods by court and invoking provisions of C. Customs Act 1978. Recovery of sums due to government as arrears of land revenue and recoveries of duties not levied or not paid or short levied or short paid or erroneously refunded and waiver of recoveries under section 11(11)(a) and C. Claim for refund of duties, sections 11B, 11D, 12A, B, C and D. Chapter 3, Powers and Duties of Officers and Landholders. Powers and duties of officers under the Act and owner or occupiers of land put to use for contraband excisable goods manufacture, sections 13 to 23. Chapter 4, Transport by Sea. Prohibition of transport of excisable goods by sea in vessels of less than 300 t burden and related matters, sections 24 to 30. Chapter 5, Settlement of Cases. Definitions, section 31. Jurisdiction, powers and procedure to be followed by Central Excise Settlement Commission, section 32 A to P. Chapter 6, Adjudication of Confiscation and Penalties. Adjudication of confiscations and penalties independent of punishments, sections 33, 34 and 34A. Chapter 6A. Appeals. Appeals to Commissioner, High Court, Supreme Court, Sections 35A to R. Definitions, Section 36. Chapter 6B. Presumption as to document. Statutory presumptions as to documents in certain cases. Sections 36A and 36B. Chapter 7. Supplemental provisions. Rule-making powers of central government, delegation of powers and sub-delegations of powers of CBEC, and immunities, Section 37, 37A to 37C, and 38 to 40. Important definitions of Central Excise Act. Excisable goods. According to Section 2D, excisable goods means goods specified in the first schedule and the second schedule to the Central Excise Tariff Act 1985, 5 of 1986 as being subject to a duty of excise and includes salt. Factory. According to Section 2E, factory means any premises including the presence thereof wherein or in any part of which excisable goods other than salt are manufactured, or wherein or in any part of which any manufacturing process connected with the production of these goods is being carried on or is ordinarily carried on. Manufacture. According to Section 2F, manufacture includes any process incidental or ancillary to the completion of a manufactured product, which is specified in relation to any goods in the section or chapter notes of the first schedule to the Central Excise Tariff Act 1985, 5 of 1986, as amounting to manufacture, or which in relation to the goods is specified in the third schedule includes packing or repacking of such goods in a unit container or labeling or relabeling of containers, including the declaration or alteration of retail sale price on it, or adoption of any other treatment on the goods to render the product marketable to the consumer, and the word manufacturer shall be construed accordingly and shall include not only a person who employs hired labor in the production or manufacture of excisable goods, but also any person who engages in their production or manufacture on his own account. Sale and purchase. According to Section 2H, sale and purchase with the grammatical variations and cognate expressions mean any transfer of the possession of goods by one person to another in the ordinary course of trade or business for cash or deferred payment or other valuable consideration. Wholesale dealer. According to Section 2K, wholesale dealer means a person who buys or sells excisable goods wholesale for the purpose of trade or manufacture and includes a broker or commission agent who, in addition to making contracts for the sale or purchase of excisable goods for others, stocks such goods belonging to others as an agent for the purpose of sale. Types of central excise duties. These duties are of five types. First is basic excise duties. Second, special duties. Third, additional excise duty in lieu of sales tax. Fourth, excise duty cessation under a specific act. Fifth, additional duties leviable on specific items. Excise duty levy could be based on one of the given grounds: A. Specific duty. B. Ad valorem duty. Specific cum ad valorem duty. Duty on fixed tariff value, levy and collection of duty of central excise. Who is liable to pay excise duty? It is a duty on the manufacturer of India. Production is thus a taxable event. In other words, the person who manufactures any taxable product would be liable to pay the excise duty. According to Section 2F, the word manufacturer shall be construed accordingly and shall include not only a person who employs hired labor in the production or manufacture of excisable goods, but also any person who engages in their production or manufacture on his own account. What is subject to excise duty? According to Section 3, 1. All excisable goods produced within India are subject to this duty. These goods are mentioned in the schedule of Central Excise Tariff Act 1985 and duty is to be paid upon them at the rates specified therein. The central government has power to fix or vary tariff values of articles by means of issuing a notification in the official gazette. Important provisions of NDPS Act. Section 1. Short title, extent and commencement. This act may be called the Narcotic Drugs and Psychotropic Substances Act 1985. It extends to the whole of India. It shall come into force on such date as the central government may, by notification in the official gazette, appoint, and different dates may be appointed for different provisions of this act, and for different states, and any reference in any such provision to the commencement of this act shall be construed in relation to any state as a reference to the coming into force that provision in that state. Section 2. Definitions. In this Act, unless the context otherwise requires, addict means a person who has dependence on any narcotic drug or psychotropic substances. Board means the Central Board of Excise and Customs constituted under the Central Boards of Revenue Act 1963. Narcotic drug means coca leaf, cannabis, hemp, opium, poppy straw, and includes all manufactured goods. Psychotropic substance means any substance, natural or synthetic, or any natural material, or any salt, or preparation of such substance or material included in the list of psychotropic substances specified in the schedule. A small quantity in relation to narcotic drugs and psychotropic substances means any quantity lesser than the quantity specified by the central government by notification in the official gazette. Section 3. Power to add to or omit from the list of psychotropic substances. The central government may, if satisfied that it is necessary or expedient, so to do on the basis of a. The information and evidence which has become available to it with respect to the nature and effects of, and the abuse or the scope for abuse of any substance, natural or synthetic, or natural material, or any salt or preparation of such substance or material, and b. The modifications or provisions, if any, which have been made to, or in any international convention with respect to such substance, natural material, or salt or preparation of such substance or material by notification official gazette, add to, or as the case may be, omit from the list of psychotropic substances specified in the schedule such substance or natural material, or salt or preparation of such substance or material. Section 8. Prohibition of certain operations. No person shall cultivate any coca plant, or gather any portion of coca plant, or cultivate the opium, poppy, or any cannabis plant, or produce, manufacture, possess, sell, purchase, transport, warehouse, use, consume, import, interstate, export, interstate, import into India, export from India, or transship any narcotic drug or psychotropic substance except for medical or scientific purposes, and in the manner and to the extent provided by the provisions of this Act or the rules or orders made thereunder, and in a case where any such provision imposes any requirement by way of license, permit, or authorization, also in accordance with the terms and conditions of such license, permit, or authorization, provided that and subject to the other provisions of this Act and the rules made thereunder, the prohibition against the cultivation of the cannabis plant for the production of ganja or the production, possession, use, consumption, purchase, sale, transport, warehousing, import, interstate, and export interstate of ganja for any purpose other than medical and scientific purpose shall take effect only from the date which the central government may, by notification in the official gazette, specify in this behalf, provided further that nothing in this section shall apply to the export of poppy straw for decorative purposes. Section 15. Punishment for contravention in relation to poppy straw. Whoever, in contravention of any provisions of this Act, or any rule or order made or condition of a license granted thereunder, produces, possesses, transports, imports interstate, exports interstate, sells, purchases, uses, or omits to warehouse poppy straw, or removes, or does any act in respect of warehoused poppy straw shall be punishable, where the contravention involves a small quantity with rigorous imprisonment for a term which may extend to 6 months, or with fine which may extend to 10,000 rupees, or with both, where the contravention involves quantity lesser than commercial quantity but greater than a small quantity with rigorous imprisonment for a term which may extend to 10 years and with fine which may extend to 1 lakh rupees, where the contravention involves commercial quantity with rigorous imprisonment for a term which shall not be less than 10 years but which may extend to 20 years and shall also be liable to fine which shall not be less than 1 lakh rupees but which may extend to 2 lakh rupees, provided that the court may, for reasons to be recorded in the judgment, impose a fine exceeding 2 lakh rupees. Whoever, in contravention of any provision of this Act, or any rule or order made or condition of license granted thereunder, cultivates any coca plant, or gathers any portion of a coca plant, or produces, possesses, sells, purchases, transports, imports interstate, exports interstate, or uses coca leaves shall be punishable with rigorous imprisonment for a term which may extend to 10 years, or with fine which may extend to 1 lakh rupees. Section 17. Punishment for contravention in relation to prepared opium. Whoever, in contravention of any provision of this Act, or any rule or order made or condition of license granted thereunder, manufactures, possesses, sales, purchases, transports, imports interstate, exports interstate, or uses prepared opium shall be punishable, where the contravention involves a small quantity with rigorous imprisonment for a term which may extend to 6 months, or with fine which may extend to 10,000 rupees, or with both, or where the contravention involves quantity lesser than commercial quantity but greater than small quantity with rigorous imprisonment for a term which may extend to 10 years and with fine which may extend to 1 lakh rupees, or where the contravention involves commercial quantity with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to 20 years, and shall also be liable to fine which shall not be less than 1 lakh rupees, but which may extend to 2 lakh rupees, provided that the court may, for reasons to be recorded in the judgment, impose a fine exceeding 2 lakh rupees. Section 18. Punishment for contravention in relation to opium poppy and opium. Whoever, in contravention of any provision of this Act or any rule or order made or condition of license granted thereunder, cultivates the opium poppy or produces, manufactures, possesses, sells, purchases, transports, imports interstate, exports interstate, or uses opium shall be punishable, where the contravention involves a small quantity with rigorous imprisonment for a term which may extend to 6 months, or with fine which may extend to 10,000 rupees, or with both, where the contravention involves commercial quantity with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to 20 years, and shall also be liable to fine which shall not be less than 1 lakh rupees, which may extend to 2 lakh rupees, provided that the court may, for reasons to be recorded in the judgment, impose a fine exceeding 2 lakh rupees. In any other case, with rigorous imprisonment which may extend to 10 years, and with fine which may extend to 1 lakh rupees. Section 19. Punishment for embezzlement of opium by cultivator. Any cultivator licensed to cultivate the opium poppy on account of the central government who embezzles or otherwise illegally disposes of the opium produced or any part thereof shall be punishable with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to 20 years, and shall also be liable to fine which shall not be less than 1 lakh, but which may extend to 2 lakh rupees, provided that the court may, for reasons to be recorded in the judgment, impose a fine exceeding 2 lakh rupees. Section 20. Punishment for contravention in relation to cannabis plant and cannabis. Whoever, in contravention of any provisions of this Act or any rule or order made or condition of license granted thereunder, cultivates any cannabis plant or produces, manufactures, possesses, sells, purchases, transports, imports interstate, exports interstate, or uses cannabis shall be punishable, where such contravention relates to Clause A with rigorous imprisonment for a term which may extend to 10 years, and shall also be liable to fine which may extend to 1 lakh rupees, and where such contravention relates to subclause B and involves a small quantity with rigorous imprisonment for a term which may extend to 6 months, or with fine which may extend to 10,000 rupees, or with both, and involves quantity less than commercial quantity but greater than small quantity with rigorous imprisonment for a term which may extend to 10 years, and with fine which may extend to 1 lakh rupees, and involves commercial quantity with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to 20 years, and shall also be liable to fine which shall not be less than 1 lakh rupees, but which may extend to 2 lakh rupees, provided that the court may, for reasons to be recorded in the judgment, impose a fine exceeding 2 lakh rupees. Section 21. Punishment for contravention in relation to manufactured drugs and preparations. Whoever, in contravention of any provisions of this Act or any rule or order made or condition of license granted thereunder, manufactures, possesses, sells, purchases, transports, imports interstate, exports interstate, or uses any manufactured drug or any preparation containing any manufactured drug shall be punishable, where the contravention involves a small quantity with rigorous imprisonment for a term which may extend to 6 months, or with fine which may extend to 10,000 rupees, or with both, where the contravention involves quantity lesser than commercial quantity but greater than small quantity, with rigorous imprisonment for a term which may extend to 10 years and with fine which may extend to 1 lakh rupees. Where the contravention involves commercial quantity with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to 20 years and shall also be liable to fine which shall not be less than 1 lakh rupees, but which may extend to 2 lakh rupees, provided that the court may, for reasons to be recorded in the judgment, impose a fine exceeding 2 lakh rupees. Section 22. Punishment for contravention in relation to psychotropic substances. Whoever in contravention of any provision of this Act or any rule or order made or condition of license granted thereunder manufactures, possesses, sells, purchases, transports, imports, interstate, exports interstate, or uses any psychotropic substance shall be punishable. Where the contravention involves a small quantity with rigorous imprisonment for a term which may extend to 6 months or with fine which may extend to 10,000 rupees or with both. Where the contravention involves quantity lesser than commercial quantity but greater than small quantity with rigorous imprisonment for a term which may extend to 10 years and with fine which may extend to 1 lakh rupees. Where the contravention involves commercial quantity with rigorous imprisonment for a term shall not be less than 10 years, but which may extend to 20 years and shall also be liable to fine which shall not be less than 1 lakh rupees, but which may extend to 2 lakh rupees, provided that the court may, for reasons to be recorded in the judgment, impose a fine exceeding 2 lakh rupees. Section 23. Punishment for illegal import into India, export from India, or transshipment of narcotic drugs and psychotropic substances. Whoever, in contravention of any provision of this Act, or any rule or order made or condition of license or permit granted, or certificate or authorization issued thereunder, imports into India or exports from India or tranships any narcotic drug or psychotropic substance shall be punishable, where the contravention involves a small quantity with rigorous imprisonment for a term which may extend to 6 months, or with a fine which may extend to 10,000 rupees, or with both, where the contravention involves quantity lesser than commercial quantity but greater than small quantity, with rigorous imprisonment for a term which may extend to 10 years and with fine which may extend to 1 lakh rupees, where the contravention involves commercial quantity with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to 20 years and shall also be liable to fine which shall not be less than 1 lakh rupees, but which may extend to 2 lakh rupees, provided that the court may, for reasons to be recorded in the judgment, impose a fine exceeding 2 lakh rupees. Section 25. Punishment for allowing premises, etc., to be used for commission of an offence. Whoever, being the owner or occupier or having the control or use of any house, room, enclosure, space, place, animal, or conveyance, knowingly permits it to be used for the commission by any other person or an offence punishable under any provision of this Act shall be punishable with the punishment provided for that offence. Section 26. Punishment for certain acts by licensee or his servants. If the holder of any license, permit, or authorization granted under this Act, or any rule or order made thereunder, or any person in his employ and acting on his behalf, omits, without any reasonable cause, to maintain accounts or to submit any return in accordance with the provisions of this Act, or any rule made thereunder, fails to produce without any reasonable cause such license, permit, or authorization on demand of any officer authorized by the central government or state government in this behalf, keeps any accounts or makes any statement which is false or which he knows or has reasons to believe to be incorrect, or willfully and knowingly does any act in breach of any of the conditions of license, permit, or authorization for which a penalty is not prescribed elsewhere in this act, he shall be punishable with imprisonment for a term which may extend to 3 years, or with fine, or with both. Section 27. Punishment for consumption of any narcotic drug or psychotropic substance. Whoever consumes any narcotic drug or psychotropic substance shall be punishable, where the narcotic drug or psychotropic substance consumed is cocaine, morphine, diacetylmorphine, or any other narcotic drug or any psychotropic substance as may be specified in this behalf by the central government by notification in the official gazette, with rigorous imprisonment for a term which may extend to 1 year, or with fine which may extend to 20,000 rupees, or with both, and where the narcotic drug or psychotropic substance consumed is other than those specified in or under Clause A, with imprisonment for a term which may extend to 6 months, or with fine which may extend to 10,000 rupees, or with both. Section 28. Punishment for attempts to commit offences. Whoever attempts to commit any offence punishable under this chapter, or to cause such offence to be committed, and in such attempt does any act towards the commission of the offence, shall be punishable with the punishment provided for the offence. Section 29. Punishment for abetment and criminal conspiracy. Whoever abets or is a party to a criminal conspiracy to commit an offence punishable under this chapter shall, whether such offence be or be not committed in consequence of such abetment or in pursuance of such criminal conspiracy, and notwithstanding anything contained in section 116 of the Indian Penal Code 45 of 1860, be punishable with the punishment provided for the offence. A person abets or is a party to a criminal conspiracy to commit an offence within the meaning of this section, who in India abets or is a party to the criminal conspiracy to the commission of any act in a place without and beyond India, which would constitute an offence if committed within India, or under the laws of such place, is an offence relating to narcotic drugs or psychotropic substances, having all the legal conditions required to constitute it such an offence, the same as or analogous to the legal conditions required to constitute it an offence punishable under this chapter if committed within India. Section 31. Enhanced punishment for offences after previous conviction. If any person who has been convicted of the commission of, or attempt to commit, or abetment of, or criminal conspiracy to commit any of the offences punishable under this Act is subsequently convicted of the commission of, or attempt to commit, or abetment of, or criminal conspiracy to commit an offence punishable under this Act, with the same amount of punishment shall be punished for the second and every subsequent offence with rigorous imprisonment for a term which may extend to 1/2 of the maximum term of imprisonment, and also be liable to fine, which shall extend to 1/2 of the maximum amount of fine, where the person referred to in subsection 1 is liable to be punished with a minimum term of imprisonment and to a minimum amount of fine. The minimum punishment per such person shall 1/2 of the minimum term of imprisonment and 1/2 of the minimum amount of fine, provided that the court may, for reasons to be recorded in the judgment, impose a fine exceeding the fine for which a person is liable, where any person is convicted by a competent court of criminal jurisdiction outside India under any corresponding law. Such person, in respect of such conviction, shall be dealt with for the purposes of subsections 1 and 2. as if he had been convicted by a court in India.
In this module, you have learned that the Drugs and Cosmetic Act was passed on 10th April 1940, and this has been divided into 5 chapters which contain 38 sections and 2 schedules, which is namely Schedule 1 and Schedule 2. We also studied that the Chapter 3 of Drugs and Cosmetic Act deals with various provisions regarding the import of drugs and cosmetics. The sections under this chapter not only define the standards of quality for import of drugs and cosmetics, but they also define the misbranding, adulteration and spurious drugs and cosmetics. So, you have become familiar with all these. According to section 8 of chapter 3, the expression standard quality means in relation to a drug that the drug complies with the standard set out in the second schedule, and B, in relation to a cosmetic that the cosmetic complies with such standard as may be prescribed. Chapter 4 of Drugs and Cosmetic Act, we studied that it deals with various provisions regarding the manufacture, sale and distribution of drugs and cosmetics. The sections under this chapter also cover the penal provisions as to the non-compliance of necessities of the manufacture, sale and distribution of drugs and cosmetics mentioned under this act. In the most simple form, excise may be defined as any duty, toll or tax imposed upon the consumption or sale or manufacture of commodities in a country, or tax upon certain trades, sports or occupation, generally taking as fees or licenses. In order to systemize the system of taxation, the Central Excise Act 1944 was promulgated. It is the basic act which deals with the charging of duty, valuation of goods, administrative and penal provisions. This act we studied had 7 chapters containing 40 sections and only one schedule, that is Schedule 2. We also studied that excise duties are of 5 types. They are basic excise duties, special duties, additional excise duty in lieu of sales tax, additional duties leviable on specific items and cesses of excise duty under specific act. We also studied that excise is a duty on a commodity produced or manufactured in India. Production or manufacture is a taxable event. According to section 3(1), excisable goods manufactured in India are subject to excise duty. We also studied that section 36A deals with presumption as to documents in certain cases, while section 36B deals with admissibility of microfilms, facsimile copies of documents and computer printouts as documents and as evidences. We also studied that India is the undersigned to the UN Single Conventions on Narcotic Drugs 1961, the Convention on Psychotropic Substances 1971 and the Convention on Illicit Traffic in Narcotic Drugs and Psychotropic Substances 1988, which prescribes several methods of control meant to attain the dual objective of restraining the use of narcotic drugs and psychotropic substances for medical and scientific purposes, along with checking of the misuse of the same. Schedule 1 of NDPS Act 1985 prohibits the import and export of narcotic drugs and psychotropic substances. And we studied that how this act outlooks offences related to drugs very seriously and penalties are rigid. The gravity of sentence and fine differs with the offence, and for many offences the penalty depends on the quantity of drug involved, whether it is small quantity or large quantity, but less than commercial quantity or commercial quantity of drugs. Small or commercial quantities are notified for each drug. And we also studied that under the NDPS Act, abetment, criminal conspiracy and even attempts to commit an offence attract the same punishment as the offence itself. Mens rea for committing a crime